Chair now recognizes the ranking member of the Subcommittee on Capital Markets, Mr. Sherman, for 1 minute.
Chairman Gensler, thank you for working hard and getting things done and fulfilling the mandate given to you by the 33 and 34 Securities Acts and bringing them up to date for the 21st century. Thank you for getting information that investors who care about the environment will want. Thank you for standing up to the crypto bro billionaires where an area where the multi-billion-dollar frauds are just the beginning of the societal harm. Investor protection is not the antithesis to capital formation, it is the necessary antecedent. If we don't protect investors, capital will go to other markets. The private placements cannot swallow the whole idea of companies being public. And the idea that 2,000 shareholders should become 2,000 shareholders of record through a phony math that allows companies to have perhaps 10,000 beneficial shareholders and not consider themselves public is something that needs to change. I yield
recognize for 5 minutes.
Mr. Chairman, Chair Gensler, I am very pleased with your attitude and your performance, but my views are my own. I'd like to speak for the gentleman from Texas, but he hasn't authorized me to do so. I won't. The chair of the committee says that we ought to have absolute clarity in this issue, and I agree with him. And we can achieve that if the chair will work with me on legislation to say that all intangible investment assets, including all crypto, are securities. That way it would be very clear that investors in crypto get the same protection as investors in stock, bonds, and other intangible assets acquired for an investment purpose. The definition of accredited investor that we have now relates to the wealth of the investor or their income, which may have nothing to do with their sophistication and knowledge. And I look forward to working with others on this committee to have a definition of accredited that discards the idea of wealth and looks instead at knowledge, but also specifies that if you're going to participate in that kind of private placement, you don't put more than 5 or 10% of your assets in any one basket. The definition of an accredited investor we have now is based on wealth levels set in the 1980s, which means they're completely out of date and probably shouldn't be used at all. Mr. Chairman, you said to the banking committee back a couple years ago, to the extent there are securities on these trading platforms, under our laws, they have to register with the commission. So assuming that a particular crypto token is a security, if that's true, is an exchange where that security is traded a securities exchange?
Under the laws, if you meet the definition of an exchange and you have securities on that exchange, yes, you have to come in and comply and register and protect the investing public.
Well, I heard you earlier say that no field in finance is so rampant with non-compliance. If there are those who are not complying with our securities laws, please shut them down as quickly as you possibly can. And I point out that the most famous crypto exchange was FTX. It is now, of course, the most infamous exchange. Congress expanded from 500 all the way up to 2,000 the number of entities that can be beneficial owners and still have the company thought of as a private company. I mean, that's a lot, 2,000 owners. But we've got a huge loophole here where you could have dozens or hundreds of beneficial ownership entities counted as only one if they list the stock in street name. Do you have the authority, and will you move toward a definition of 2,000 that reflects 2,000?
I think you raise a good point, and I've asked staff for recommendations for the Commission's consideration, really to ensure that Congress's will about these numbers, the 2,000 number you reference in the Jobs Act, it really means 2,000, and how to look at, as you say, street name ownership that a broker might hold for hundreds of thousands.
I think you'll find companies calling themselves private that have many, many thousands of beneficial owners, and that's not what the securities law calls for. Companies, when they file their 10Ks every year, they list their risk factors. One risk factor that's increasingly important is the risk of a disruption in the U.S.-China relationship or economic relationship. If investors got explicit information about that, that would protect investors. If companies had to fight for capital by demonstrating their resiliency, their ability to withstand such a breakdown, then our entire country would be more resilient, and Taiwan would be more secure. Can you move forward to be more explicit and clear with companies that they need to disclose the risks to the company and hopefully what they're doing to ameliorate that risk of a possible breakdown in the U.S.-China relationship?
Under current rules, companies need to disclose material risk, and if they have operations and there's material risk related to any geopolitical area, not just the one you mentioned, they're obliged to disclose that.